What happens when a defendant tells witnesses not to show up just hours before his trial? In the case of Stephen Estrada, that question just set off a courtroom firestorm. With new evidence dropping at the last minute, a determined defense attorney, and a judge who's not backing down, this case just exploded.
And I'm sorry, I don't know if it's common law wife, girlfriend, I'm unclear in the status, but significant other. I know you don't like the word baby mama, and I don't think it's the baby mama, so I'm not going to say that. Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. Okay, I'll hear it. Court is calling 2022 CR 11013, State of Texas versus Stephen Anthony Estrada. Can I have parties announced for the record for the state? Defense?
Eddie Bravenec for the defense.
All right, this is scheduled for jury trial today. Defense, you're asking for a continuance?
I am. Your Honor, as you might have noted, starting about 2 weeks ago, I came by the court, sent the court emails, sent the prosecutor emails asking which case we were going to be trying. Reason for that is I wanted to be prepared for today. As I've told the court before, there's no on time, there's either ahead of time or behind time. This particular case, when I say it's an identification case, what I mean is that there's no question that Mr. Estrada's co-defendant is the person in the video. Everyone can tell that. The people that are identifying Mr. Estrada as being a co-defendant, because there's a mask worn, are two people. In this particular case, and the reason that on 13 they're trying to go forward, there's a clerk, I believe, that says they recognize his eyes. Pretty weak identification. But then there's a stronger identification. And the stronger identification is, and I'm sorry, I don't know if it's common law wife, girlfriend, I'm unclear in the status, but significant other. I know you don't like the word baby mama, and I don't think it's the baby mama, so I'm not going to say that.
You mean the mother of his child?
Correct. Yes. And I've heard you say that before, and I agree with that. I think it's disrespectful too. So when I say that this case is triable, it's triable on identity theory. Because of that, our defensive, and I hate giving a defensive strategy, but I have to explain why I need a continuance. Our defensive strategy essentially is that it's not Mr. Estrada, that if his girlfriend comes in and says it's not him or a significant other, whatever it is, we have a fairly weak identification. There's no fingerprints, there's no other information. So the defensive theory is that it's co-defendant's friend, brother-in-law, guy he met somewhere. In other words, this is completely a blame the co-defendant. I don't so much mind saying this is fairly obvious. So I prepared for trial. I have in my pocket a thumb drive with all the information that I have completely reviewed to be prepared to go in front of you today. So two things have happened. The first thing you've already heard about it, and I'll take last. But the second one is I'm now told that there's some discovery that is being uploaded today. I prepare ahead of time. I am sure that for the state, this discovery is not important. It doesn't go to their theory of the case. Of course, it goes to Mr. Estrada's right to have an effective defense. I do prepare. I want to look at the discovery. I don't know what it is. And I'm not asking for an inordinate amount of time. You bring me back 2, 3, 4 weeks, I'll be ready. Well, I see you shake your head no.
No, not 2, 3, 4 weeks.
Oh, okay.
Mhm.
But what I'm telling you is that I may be, and if you say next week, that's fine too. It isn't a question. I want to do the right thing the right way. I want to look at the discovery and judge if it doesn't make a difference. Of course, I'll be ready. If it's earth shattering, it'd be different. Now, there's some other tangential issues that you've already indicated in my motion that are not a proper ground. Fair enough. We can have that.
What would that be?
Well, there's a audio tape where some witnesses say to Mr. Estrada that they came by and served us on a murder. This is an agate robbery case. And they say, it's not the case you were thinking about. And he says, don't show up on that murder. Now, I think there's a good question whether or not that's wrongful, telling someone not to show up for an different case. That's an issue that I think in the next week, I'll be better prepared for. The next 2 weeks or whatever you tell me. And I'll await your ruling on that. And I want to be prepared for that. And I will be prepared for that as well. But the reason I'm asking for time to review the discovery they've uploaded is I know it's not important to them, but I think that a week or whatever you give me is a proper amount of time for us to look at it and me tell you, Judge, I'm ready now or not. Absent the two issues, one of which you said is important, but I want to preserve the record. the other that I believe is important, I would be ready today. And I tell you truthfully, as an officer of the court, I've been working for the last 2 weeks. You've seen me in the court. I've asked the court in open court what case was going to be tried. I wanted to be ready today. I respect you, and I want to be ready next week, or if you call me back on Friday, whatever you do. I'm just saying, I think it's not allowing me to be effective for Mr. Estrada to ask me to look at discovery last minute that very well may change our theory of the case. Now, do I blame the state? I don't know enough to blame them, but it's a situation we're in, and that's why I'm asking for the limited amount of time that the court would give me.
Judge, I'll address the forfeiture by wrongdoing first. So, Judge, they do talk about a murder case. My understanding is that our investigator did slip of the tongue because there was another murder case on the docket that he did mention murder. But in the phone call, which I don't believe defense counsel had the full opportunity to listen to because they walked away to go talk to their client. Sorry, Diana. That he mentions, regardless, I'm gonna get 25. Don't show up. If you guys show up, they can prove my case. So they know that it's in regards to the cases that we're alleging against him. And he repeatedly says, please don't show up. He talks about the consequences of if they do show up and present testimony in this case, and they aren't here. They were served yesterday and were given notice to be here. In regards to the second issue, I did tell Mr. Brobenick that this was information related to the co-defense's cases in the fact that it was evidence specifically linking the co-defendant. I don't believe Mr. Estrada gets brought up in these other cases. I did see that he has a hard drive. I can upload that right now. And
so you're saying this co-defendant is evidence, the co-defendant's information that you're uploading is evidence that links Mr. Estrada to this case?
No, it links the co-defendant to the case. I don't believe Mr. Estrada is really linked through that evidence. The only evidence that we intended to show was the evidence that's already been uploaded as of today.
Mhm.
Again, not including the stuff that I've been uploading right now, but previously. This was more of we checked, we wanted to make sure that we had everything in this case because of the co-defendant and because of the length of investigation. And so that's why we took the time to go and see if there was anything else. I think if Mr. Brobenick takes a look at that other information, there are several other cases that are looked at with the co-defendant in mind, but specifically the one that we're looking at, I can point out and say this evidence was already uploaded.
All right. So you're saying the evidence was already uploaded?
Yes, ma'am. There was significant evidence that was uploaded in this case and the other cases that Mr. Brobenick was already assigned.
All right. And the evidence that was uploaded that you say is already uploaded and you're saying significant, what do you mean by significant?
So it was just all the cases had their own e-discovery, links. And so it's just each case, it's just more and more evidence for whichever specific case. But when linked together, the evidence that was previously uploaded, that's our case. You know, we're not going into the new stuff. I'm not going to present any of the evidence that was uploaded later.
So the evidence that you're saying was uploaded, has he already had access to it?
Yes, ma'am.
I don't know if I have or not. What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I prepared by uploading each and everything in the case to this drive. And when there's additional information, I'm very concerned about going forward. It's the whole reason that we signed those discovery acknowledgements, which I cannot sign today.
But what he's saying is that it's already been uploaded and it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we are trying today. I believe that evidence might be to another case, might be somewhere else, but I asked them, and I've been in open court and said it, I want every piece of information on this case. So if they're intending on bringing information from other cases, that was the reason that I went here today and said, what case are we trying? And I want to be prepared on it. On the the forfeiture thing, I actually pulled the number of subpoenas that have been done today. I went to the district clerks and there's only one subpoena requested on file on this case. I have a copy for the court. It's on Emily Rose Fritz, which is none of these individuals, and there's a return on her. So if there has been a subpoena done, I wasn't on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mess with the witnesses, but I can only prepare him for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on a case that we've.
I'm talking about the asset,
Yeah.
the forfeiture.
So the forfeiture by wrongdoing,
Mhm.
I do not know whether, because and I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
Well, the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out. And then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not. So are you saying that if there's somebody in custody or not in custody on bond, well, no, let's say they're in custody, that to get out of a trial, all they have to do is, if your trial is on, let's say hypothetically, February 6th, you can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically, that person gets a continuance and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th, telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets a continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada, and these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me, but I'm just trying to figure out everybody's legal thoughts on certain situations.
Judge, I started out a long time ago thinking I knew everything about the law.
Mhm.
I have been dispossessed about that idea.
Oh, me too.
The answer is I don't know.
Mhm.
And when I say I don't know, I'm being straightforward and honest with you. I do not know the status of the law. I do not know the status of the subpoenas. I don't know this issue. And this issue popped up at the last moment. And it did pop up at the last moment.
Well, Mr. Brabenec, not to interrupt, but I will tell you, I know the law on that unless it's changed. You know why I know the law on that? Because when I was a prosecutor, and Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls, and the night before, whoever the defendant is has called that person and said, do not show up to court. If you don't show up to court, they're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
The law
by
didn't
wrongdoing.
change, in fact, since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
Yeah, more than that.
Okay.
But I always try to keep up to date on law. So
Well,
I reviewed it.
so your specific hypothetical was about when you were a prosecutor and you knew the knowledge was from back.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were prosecutor, which is where you let me know, and it changed in 2021.
Mhm.
I can't tell you in this specific fact because I've done not a briefing. But you had already indicated to me off the record that you were not going to grant a continuance on this particular
No,
ground.
not on, not because you've got new information that your client allegedly called someone from the jail last night on the 5th. At least that's what's in your motion too. On the 5th, I believe, asking somebody not to appear for trial.
Well, Judge, as you know, when I wrote this, I hadn't listened to the audio tape yet.
Okay.
So it's very difficult for me to make a good legal argument when I have yet to look over the things or read the things, which really brings, since you had already told me you weren't going to grant a continuance on the thing that you are now indicating you're not going to the grounds that you should grant a continuance, which is that I don't know. They're telling me there's new discovery that they don't believe is material. I'm telling the court I don't know. I'm also telling the court I prepared. I'm telling the court I downloaded everything. I'm telling the court that now with this new information under Michael Morton and under the Texas Supreme Court cases, I believe I'm entitled to time to review it. And I'm not asking, I've been a trial lawyer 24 years, which I believe is a little less than you, but I'm not asking for a lot of time. I believe in a week I could be here standing and say, Judge, I'm ready. They were right. Or Judge, we've got an issue. And if there's an issue, I'll come by on Wednesday, Thursday, Friday, as soon as I can. In other words, I'm not going to let it sit out there. But at this point in my career, I am unwilling to take the other side telling me that something is not material to my client's case and is not important.
You're coming back tomorrow for trial. That's the time you have. So whatever he needs to see, he needs to see it.
Yes, Judge.
If he needs to listen to that video, the audio from the jail, he needs to listen to the audio from the jail about your request for forfeiture by wrongdoing. Y'all are here, listen to it. But you're coming back to trial for tomorrow.